Hi there, everybody. On this episode of the AFSA Extra Credit Podcast, we're diving into a topic that may not grab headlines, but has major implications for vehicle finance companies, compliance teams, and consumers alike. Repossession notice requirements and emerging state legislation. I am not nearly an expert on this issue, so we brought in AFSA's Danielle Arlowe, who will join the podcast and lead the discussion with Jennifer Keyes, Senior Vice President of Compliance at Covius, and Matt Isaacson, Senior Regulatory Counsel at Covius. Together, they break down two closely watched state bills, Massachusetts Senate Bill 2945 and Colorado House Bill 1261, and explain why proposed changes to right-to-cure notices, post-repossession notices, lease treatment, and deficiency rules could create major operational and compliance challenges for auto finance companies. If you work in servicing, compliance, recovery, or public policy, this is a conversation you won't want to miss. Now, I'll turn it over to Danielle to lead the discussion.
Thanks, Dan. Thanks so much for letting me pop into your podcast here. This is super fun. We're really excited about our two guests today. They're from Covius. We've got Jennifer Keyes and Matt Isaacson. Welcome, Jennifer and Matt.
Glad to be here. Absolutely.
This is great. Thank you for having us.
Can you tell us, before we get into the meat of what we're going to talk about today, which, spoiler alert, has to do with a bill in Massachusetts, will you tell us a little bit about Covius and Covius's role in the vehicle recovery space, but also your specific roles at Covius?
I'm Jennifer Keyes, and I'm the Senior Vice President of our compliance group at Covius. So I lead the team of attorneys and analysts that handle all of the compliance aspects of our services. At Covius, we are a financial service provider for the mortgage and auto industry across originations, servicing, and due diligence. Our team here is focused on the compliance aspects, so identifying new laws and regulations, specifically how they impact borrower notices. At Covius, we manage those notices. We have template libraries that our clients utilize that are compliant at the federal and 50 state level, and then we print and mail those out according to the requirements. That's really our main focus.
Yeah, and I'm Matt Isaacson, Senior Regulatory Counsel. I'm one of those attorneys that reports to Jennifer Keyes. I am specialized in our vehicle finance offering, so we maintain a library of right to cure, NOI, and post-sale notices for all 50 states. And we're thrilled to be here. So let's get it going, huh?
Okay, great. Will you explain just one more foundational question? Will you explain what right to cure is for anybody who just accidentally happened onto this podcast?
Yeah, so some states have a requirement prior to repossession where you need to send the consumer. It could be a lessee or on a secured retail installment contract. You need to send them a notice giving them a time period to cure their missed monthly payments and possibly, depending on where you're at, late fees or other charges that could be included in that. And so it just gives you time before the vehicle finance company could repossess your car to come current.
Okay, excellent. And then the post, will you just say one little bit about the post repossession notices as well, just to explain that to in simple language?
Sure. So post repossession, the UCC in all 50 states will give you a right to you'll get a notice letting you know when the vehicle is going to be sold, certain rights about how it's going to be sold, if you're going to owe a deficiency after the sale or not, that you're entitled to a refund, or if the vehicle sells for more than what you owe with all the expenses, that you could get a surplus, you could get what's left over. And that's based off the UCC. Some states then have additional rights and disclosures that have to be included in that pre-sale notice. But you should get one of those prior to your vehicle being sold. And the point is to give you an opportunity to possibly either reinstate that some states offer, or to redeem the vehicle and purchase it back before it's sold.
Matt, I'm so glad you mentioned the deficiency balance because one of the challenges we face when we're talking to lawmakers about repossession is this false assumption that creditors just like love to repossess vehicles, and we have to explain to them that it's an absolutely a last resort situation, and that any that there may be a deficiency balance, but whatever is collected for the sale of the vehicle goes back to the consumer, either credit against that balance or literally in money straight to them if it's in excess of what is owed. I'm so glad you mentioned that because I feel like that's the biggest misconception about repossession in our industry. Let's talk about this bill, Massachusetts Senate Bill, we call it SB 2945. You all raised this I know it's in our tracking system, but you all raised some of the interesting and unique items that are in this bill to us. So we thank you for that. Should we get right into it?
Yeah, sure. It's the bill's titled An Act to Modernize Protections for Consumer and Automobile Transactions. And I think the intent of the bill is to give lessees, that'd be consumers leasing a motor vehicle for their personal use, the same rights in the Commonwealth that are given to those who are buying or have a loan against the vehicle. And there's some complications and difficulties in trying to take a leased vehicle and try to plug it into the same rules that apply on a retail installment sales contract, just because those laws were not designed to necessarily fit together. They're two different products, two different types of transactions, and so trying to fit a square peg into a round hole, I think it could lead to a lot of difficulties in trying to comply for vehicle finance companies that have lease collateral in their portfolio.
Yeah, right. Like two different owners, in fact, as in addition to all of the two different things that you mentioned. Okay, so will you explain about what this right to cure notice requirement would be for leases if SB 2945 were to pass?
Yeah, so what I think on the right to cure side, it's something that vehicle finance companies are aware of because they have to offer it on their retail installment sales contract. The notice just updates some of the wording to include leases. So the bill, it spans the definition of some of the definitions to include leases, where previously in the Commonwealth, those were excluded. And there was actually case law about that, excluding leases from this. So it would overrule those cases. It would require a right to cure notice for leases. It's similar to what's required on a retail installment sales contract. There would be a 21-day cure period. So it would allow, like we mentioned earlier, 21 days for the lessee to come up with the money for that they're behind on to get their vehicle back. So that it would be a new process for those who have lease collateral in the Commonwealth.
You mentioned some court case. Are you referring to the Williams case?
Well, the Williams case, I think, really comes into play on the post-repossession notice. So that NOI, the notice that you would send prior to sale, and also with that potentially applying a post-sale notice, instead of on the leasing side, instead of using like a realized value to determine any kind of deficiency, I think you would have to look at that Williams case, and now maybe you're using the fair market value of the vehicle instead of necessarily what you got for it at an auction or what you sold it for, and that creates its own issues because that's not, so the Williams case, it dealt with a retail installment sales contract. And the basics are that you at least at a minimum on your pre-sale notice and on your post-sale notice have to reference fair market value. And so, in doing that, you'd have to make a determination, each vehicle finance company would, to determine, are we going to apply this case preemptively before we know whether or not a court in the state would say you need to use fair market value. But that part of the fair market value comes from the statute that this bill is amending, but it doesn't amend that section. So I think it's likely that you would need to do that, or you definitely have to take a look at it and consider it.
And fair market value is, I realize you can talk about it objectively, but it really is, I mean, it is what the vehicle would sell for, but we're talking about the wholesale space versus the retail space. It seems like there's just a disconnect there. What would be some of the difficulties of extending a law intended for secure transactions to leases? You touched on it, but I wanted to see if there's anything else you wanted to add to that.
Yeah, I think so typically with leases, if there is a surplus, usually the vehicle finance company will keep that. Here, if you're going to apply, Part 6 of Article 9 to a lease, all parts of the sale have to be commercially reasonable. And so you would also, in your pre-sale notice, part of that notice is telling the consumer that if there is a surplus, that they're going to get the money back unless it has to be paid to someone else. And so it changes that aspect to now, if you have a surplus, you're probably going to need to refund that to the lessee. There's some other issues. Then, I touched on it. The sale would need to probably be commercially reasonable and fit that. You then are going to have to send, if you want to collect on this debt, you're going to have to send a post-sale notice. And that post-sale notice has very defined what you need to disclose and in what order. And it doesn't really fit with leasing, with the various expenses that happened when a lease is terminated early, like an early termination fee, turn-in fee, various taxes sometimes on the turn-in. So there's various things that, I mentioned earlier. It's somewhat trying to fit a square peg in a round hole, because it's not an identical product, right? Like a lease is more like a rental, and you're gonna, at the end of it, you're gonna turn it in. Whereas, with lending, the goal is that the consumer owns the vehicle at the end of the loan or at the end of the contract. So those are some of the difficulties, I think, that. And it's not clear from the bill necessarily that you would need to send a post-sale notice. So like a lot of these things, there's not a lot of clarity, which I think all of us who are in this space know that the defined representatives that we have in state government are not always up to speed on to this level of detail. But I think there's definitely ambiguity enough that you'd really need to get some direction from your local counsel there, or from the state regulator.
It is really difficult. Yeah, obviously they can't be experts in everything, but this gets down to such granular detail that, there really aren't experts except for people, like yourself and your peers anywhere. So I think it is important that we articulate those points to them. Does the prohibition of collecting a deficiency balance apply to lease in this bill to leases when the unpaid balance of the consumer's obligation at the time of the default is a certain dollar value?
Well, I think that's definitely an open question. I think if it was my decision, I think it probably doesn't. But once again, if you have a court looking at this and wanting to craft an outcome favorable to the consumer, I think that the risk is that the obligation in a lease is the monthly payments, right? It's not the entire balance of what would the entire realized value, let's say, or what's left at what's defined at the end that the value of the vehicle is going to be. So, if it's $2,000 and let's say your lease you're at the end of your lease and your lease payments are $400, you could potentially walk away from it about 5 months early, and there wouldn't be any recourse if that applied. It may or may not, but it's one of those sections in current law that's not amended by this bill. And so, it'll be an open question potentially that you could see a plaintiff's attorney raising, right, and litigating and maybe getting past like a motion to dismiss or something like that, where there's real expenses, legal fees and expenses that kick in with litigation.
Would this put if this bill were to pass, would this put Massachusetts way out there compared to other states on the notice side?
Yeah, I think it'd probably be most similar to what's going on in Maryland, what's been established in Maryland law. They have a kind of a reinstatement, a redemption. I think what complicates this is that Williams decision from about maybe 2018, 2019. It's been a while now, using the fair market value. Because usually things like that, like realized value and things like that, in leases are defined in the lease, right? A lease is a contract. So a lot of those contractual terms and definitions and things like that are put into the lease at the time the lease is created. So that it would be something where you would need to look at that. But no, it wouldn't be the only state where you would have a right to redeem, to buy the leased vehicle for a time before it's sold. But it would be kind of an outlier in that most states don't have, this reinstatement cure period for leases. I mean, there are more on the right to cure side that have a right to cure requirement prior to the vehicle being repossessed. But I think where the difficulty is it appears that they're going to try to apply Article 9, Section 6 to leases. And I think that would be an outlier.
Well, since notice is your special expertise, this introduces a new pre-sale notice requirement, you said. Would it look like the UCC safe harbor notice, but with Massachusetts specific language? What would it look like?
Yeah, I think it would look like that. And I think you would, you obviously would use that. Part of the Williams holding said you needed to use fair market value instead of the sale. There was specific language that was called out by the Supreme Court in the Commonwealth that you can use to meet that Williams requirement. So yeah, it would look like that safe harbor notice, but with the with that overlay of the Williams decision added to it, or in place of one little paragraph. But when you use the safe harbor notice, you're telling the consumer, or the lessee in this case, that if there is a surplus from the sale, that they're going to get it, unless it's paid to someone else. So that's one of the difficulties. And then also, if you're going to try to collect on a deficiency, you're going to have to send them a post-sale notice compliant with the UCC, with Section 615. Section 616 is the notice, but the proceeds section is 615. So it's I think that's where it gets real difficult on the leasing side.
Okay, now if it's okay with you, I want to pivot a little bit to another bill that we saw this year that is dead for now, and that is Colorado HB 1261, also related, very broadly related to vehicle sales, consumer protections related to repossessions. I guess I'd say that in that bill, we saw a lot of stuff on repossession and notification. Did you have any comments on that, though? I thought that was a real outlier, and we do think it will be back.
Yeah. I was thrilled that it died, frankly, because
Yeah.
it didn't give a vehicle finance company a lot of time to make these adjustments. And what I think probably one of the more difficult parts was, I mean, they had like a 60-day cure period on a right to cure. So let's say your practice in-house was to wait 30 days before you sent the right to cure. They get a month behind. Maybe you let them get 2 months behind. You're adding 60 more days that you can't repossess the vehicle. So potentially that's 2 more missed payments. It's late fees. It's, the whole amount of charges. So it just increases the amount that the consumer may end up owing. And a 60-day cure period would be definitely way outside the norm of what we see in other states across the country. Usually these cure periods are, 10 to 20 days, somewhere in that range. Maybe 25 is probably one of the longest. But 60 days is, a long, long time. So potentially you're probably 90 days delinquent when that, at least at a minimum, when that 60-day period elapses.
That it was, yes, thank you for explaining that. That was one of the crazier things in a very crazy bill. Also, I can't get over this concept of, I think the sponsor wanted, if a vehicle were, if there were some kind of um, a cure, or if there were, or if there was, a paying of what was owed, I think is how they described it, that it would restore consumers' rights as though the default didn't occur. And we had a lot of questions about that, like, do you have to re-age due dates? And what about, things about, forget about notice for a second, just other things like, how do you have to, like, how could you change their credit report? It was a difficult, it's a concept that makes sense conceptually, but just effectively it was very difficult for us to even kind of imagine. Is there any other legislation? Oh, yeah, go ahead, Matt. What were you
Well, no,
say?
I was just going to say, like, on the timing thing too, like, if, let's say, the consumer didn't cure and the vehicle was repossessed, they got 48 days following the repossession then to reinstate. And basically reinstatement is getting caught up on your missed payments and some of the other, late fees and some of those repossession expenses. But 48 days more added on to 60, you're getting into basically, by the time this vehicle would ever get sold, being, 5 or 6 months, in default. And it sounds like a good thing to do for consumers. Hey, we're going to give you, 150 days basically, or 130 days to get caught up and keep your vehicle. But over that time, the vehicle's depreciated. You have additional storage and repossession related expenses that it just increases the amount that they end up owing after the fact, after the vehicle's sold. And so some of these things look good on paper, or they seem very, very nice and very consumer friendly, but they end up not being so in reality when somebody is trying to collect for you because they've had to store a car, probably 120 days longer than they would in, let's say, Arizona or Utah or Kansas, any of those neighboring states around Colorado. So yeah, I mean, it's something definitely that I think vehicle finance companies are going to have to pay attention to and may need to get involved in the process out there to try to rein it in. I mean, Colorado already has a right to cure notice requirement that gives consumers 20 days to do that. But if the bill, the way it's drafted, it only would apply to qualified vehicles. So it makes it difficult then to determine what isn't a qualified vehicle. And then you're basically jumping back and forth between notices because this bill would add a new section to the Colorado UCCC, but it doesn't repeal the other requirements. So you're potentially you'd potentially need to have two or three different right to cure notices in the state and a couple of different pre-sale notices, NOIs, depending on what type, if it's a qualified vehicle or not. Very, very difficult to operationalize that, right? For your staff to know, is this a qualified vehicle? How many times have we repossessed it? Things like that. Have they cured it previously? All those things would factor into a decision on what type of notice you would need to send.
Well, Matt, you articulated some of the things that we were the most concerned about that bill. You articulated absolutely perfectly. And we didn't even get as far as that many extra notices, imagining that. That is really more even to think about. And just the one thing we did try and explain was just how much more it would cost consumers because the vehicle's losing value and you're incurring more storage fees and stuff. But you really outlined that bill perfectly. Hopefully it won't be back. We think it might be, but we'll hopefully the sponsor's been very open about conversations with the industry, which we do appreciate his approachability for sure. Jennifer, is there anything that you want to add to the conversation? I mean, you've got this sort of big perspective on all this whole compliance areas, or anything else you wanted to add about Covius or as part of the conversation?
Yeah, I think I just want to reiterate what we talked about. As we talk through these proposed laws, I know Matt and you pointed out there's a lot of complexity in those laws, and sometimes it's unclear. There's a lot of ambiguity. So I do think it's essential to partner and have that open conversation with legislatures, because to your point, the auto industry does want to do the right thing by its consumers, by its borrowers. So that clarity is just really essential. And we just know that sometimes we don't get the clarity that we need in time. So we are forced to make those real-time decisions. And to your point, that's when we really need to lean on experts like you at AFSA and those that really specialize in certain areas. I know at Covius, our sole scope is the notice side of things. So we have that great expertise on that. So happy to help on that.
And that treasure trove that if you get into the worst situation, which is litigation, to be able to go back and prove your notices, that is so critical. We appreciate your partnership. And we appreciate you specifically, Jennifer and Matt, for your time today. Thank you so much for joining us. And we'll turn it back over to you, Dan.
Thanks for listening to the AFSA Extra Credit Podcast. Don't forget to follow AFSA on X at AFSA_DC and AFSA Sticker from the Affairs team at AFSA_SGA. We're also on LinkedIn. Just search for AFSA. The blog at AFSAonline.org is a great resource to get the most up-to-date news. If you've got questions or you'd like to suggest a guest, please shoot us an email at membership@afsamail.org. Click. Until next time, thanks for listening.